Ever wondered how contracts work in Pakistan? The fundamental principles are encapsulated in the Contract Act of 1872, a law that continues to govern contractual relationships over 1.5 centuries later. But like all laws, it has evolved over time, adapting to the nuances of legal and socio-economic changes. The Contract Act of 1872 is the foundational legislation that provides the legal framework for contracts in Pakistan. It outlines the essential elements that form a contract, such as an offer, acceptance of that offer, consideration exchanged between parties, and the intention to create legal relations. It also clarifies the capacity of parties to enter into a contract and the legality of the contract's purpose. In addition to defining these basic elements, the Contract Act also categorizes contracts into types. There are express contracts where terms are explicitly stated, implied contracts which are inferred from the party's conduct or circumstances, and voidable contracts where one party can choose to enforce or void the contract. But what about when things go wrong? How do contracts end in Pakistan? The Act addresses this as well, stating that contracts can be terminated through performance, agreement, frustration, breach, or operation of law. These principles are akin to those found in many other legal jurisdictions. When a breach of contract occurs, the Contract Act provides remedies. These include damages, specific performance, and injunctions, among others. These remedies aim to compensate the non-breaching party for losses incurred and to enforce contractual obligations. The Act also includes special provisions regarding certain types of contracts. These are contracts of guarantee, contracts of indemnity, and contracts of bailment and pledge. Like in many jurisdictions, Pakistan also has a statute of frauds. This means that certain contracts must be in writing to be enforceable, as specified under the Contract Act. The interpretation and application of contract law in Pakistan is influenced by judicial decisions and case law. These decisions help clarify legal principles and resolve disputes, shaping the evolution of contract law in the country. In summary, the law of contracts in Pakistan, as governed by the Contract Act of 1872, provides a robust framework for entering into and enforcing agreements. It ensures fairness and certainty in commercial transactions and other contractual relationships within the country. So the next time you're involved in a contract in Pakistan, remember, it's all under the watchful eye of the Contract Act of 1872.